How to pass on your Georgia house to your kids without touching the probate court. Let's talk about that. Did you know that in Georgia, even if you have an ironclad will, it can take months, and if people are fighting, years before somebody gets the permission to go sell your house so that after you die, then they can get access to the equity in that house, and then you could bless your children. We're talking months and years depending on the county you're in, because some counties are slower than others, and whether or not people are getting along. So today we're going to be talking about how you can get together a foolproof plan to make sure your children get the house with avoiding probate. And we're going to go through the continuum because there's a lot of people who don't plan. So we're going to talk about what happens when you don't plan, what happens if you put some of the plans in place, and then what happens if you make it ironclad. So let's jump right in. As a real estate agent who helps people through the probate process and helps them sell their loved one's home, I run into the majority of the people who don't plan. They don't have a will. And when you don't have a will and you have children involved and you want to make sure that your children get your house, really it's the state who dictates who gets that property. And if you're in one of those marriages where you're like, well, hey, I really kind of want my house to go to my kids and not my spouse, because maybe they are going to be taken care of by their children. If you don't have a will stating that, then the state is going to say, well, your spouse gets at least 1/3 and your children gets at least 2/3. And if people aren't getting along, then all of a sudden your children could own a house with somebody that they might not want to own a house with, and vice versa. Having no will whatsoever and leaving it up to the state is really not a good plan, because you can't guarantee that those kids are going to get the entire equity out of the house or inherit the entire house. And if there's minors involved, you want to talk about opening up a can of worms. If there's minors involved, the state is going to hire a guardian, and everybody's going to be stuck until them children of yours get up to be 18 years old, because they want to make certain that those children's best interests are taken care of. And so that could just really cause a whole lot of problem between everyone involved. Let's talk about one of the protective layers. One of the protective layers is going to be that will. But there's a big myth out there that if you have a will, oh, it avoids probate. And oh, no, it doesn't. It does not avoid probate. So even in that will, if it says, I want my son and daughter to inherit this house, then they have to go through a probate process. Now, if you have a will, it tends to go a little bit faster than when you don't. It still doesn't mean that people immediately get their letters of testamentary. You got to have the original will, so copies are not allowed. And if somebody does get their letters of testamentary and somebody's not happy with how maybe somebody got wrote out of a will or something, they can object and stop the whole process. And that's where it can take from months to years to get through that. And extra money, of course, extra money going in between lawyers. Everybody lawyers up to try to make sure the will is executed as it should be, and it can just get dragged on and on and on. Now let's talk about deeds. Deeds is another layer that you can put in, and I want to caution you on some of the deeds that we have that avoid probate. The first one is joint tenancy with rights of survivorship. So a lot of people are like, oh, I'm going to put that on this deed because it's going to avoid probate. And that's true. It will 100% avoid probate. Anybody who has joint tenancy with rights of survivorship avoids probate. The only thing that has to happen is somebody have an affidavit and a death certificate. They take it to the courthouse. They record it in their names after their loved one has passed. So when that's the case, then it will pass. But there's this tax implication that can come along with that. So when you put a child on the deed while you're alive, they inherit your carryover basis. Your carryover basis is what you bought the house for. And if they weren't on that deed and you were to pass away, then they would get what's called step-up in basis. And whatever the day that you were to pass away, whatever the value of that house is, that's what they would inherit. So when they don't get the advantage of inheriting it, the step up in basis, then they're going to have a capital gains incident when they go to sell that house, because it's probably not their primary property. The only time you ever get to take the 121 exclusion on a house is when you live in it. When you live in it, and you're single, you can take up to $250,000 exclusion from capital gains, and if you're married, it's $500,000. So a lot of people will put their kiddos on there, and their kiddos own another house as their primary, and then now you got to sell it. They only get half step up in basis because you passed away. So then they're on the hook for a portion of the capital gains, and what you thought you were doing good to kind of keep them out of the trouble that is probate cause them an IRS tax implication. So I always avoid people in doing this, and if they talk with an estate planning attorney who's telling them to do this, you need to go in with eyes wide open, because there could be some reasons why you choose to do it. I won't get into that here, but if you do choose to do it, eyes wide open, everybody understands that there's going to be a tax implication down the road, unless the kiddo moves into it and makes it their primary. I've had somebody do that, actually. Have somebody right now who's on the deed with his mom's in memory care, and he's moving into this house so that he can make it his primary, and if he ever sells it down the road, he can do his he can utilize his exclusion. But gosh, some kids might not want to move into your house or can't, so it's not a good solution. There's a transfer upon death deed. Transfer upon death deed is relatively new to the state of Georgia, and from my understanding and talking to some of the attorneys, the legal ease around it's not ironclad. So you have to follow it to a T. There's a beneficiary that's named, and that beneficiary has 9 whole months after their loved one has died to go down to the courthouse and say, hey, I'm the beneficiary of this, put it in my name. So it's not the best way, I think, that you could do things. Again, talk to an attorney. I'm not an attorney. Go in with it with eyes wide open. Okay, now you want my ironclad way to be able to pass on this home to your children and avoid probate. It's a trust. Now, I have lots of people that go, trusts are expensive, and they are. It's way cheaper to go do a will. It's way cheaper to get these deeds set up. Like a closing attorney around here, a couple $100 to draw these kind of deeds up and record them at the courthouse. But in the long run, and on the back end of this thing, it could be cheaper. So on average, depending on the estate, and if the estate's complex, it's going to be more money. But on average, it costs about $5,000 to set up a trust. You also have to fund the trust. So once you have it set up, all the assets have to go in that trust name. That if you don't put your property in the trust's name and you die, guess what? That goes through probate. So you got to fund it. But a trust is a really good way to set up how you want things to go down. You can have a will right along with the trust. You can name a trustee. It could be your child. After you pass away, it could be an attorney. Whoever you name, there can be a trustee. And after you pass away, that trustee can act immediately. So if they need to put that house on the market and get it sold because maybe the children need money fast and all the equities tied up into the home, then they can act immediately, get it on the market, get it sold, and get that money distributed to the heirs appropriately. Trust can be sued. Of course, we're in America. Anybody can sue for anything, right? But the thing about a trust is that it does not stop the trustee from doing their job. So if they are needing to sell that house, they can go ahead and sell the house, even if there's a lawsuit going on. So that is the benefit of a trust. Now, I have seen things go sideways where somebody had a will, and then you had some people who objected, and it cost him over $12,000 to fix. You might want to spend the extra money up on the front end to save a lot of heartache on the back end. Because that's another thing. If you write somebody out of your will, you're still considered an heir and still have to be notified, even if they're written out. So fun times, right? When people aren't getting along or you're writing people out of the will, there could be problems. So I hope you like this kind of content. If you need a good attorney that I can get you in touch with because you're like, hey, I want to do a will, or hey, I'm interested in that trust, let me know. I'll connect you to some attorneys I know. And if you like this content, well, hang around. We got more of it. And if you're going through the probate process, I do have a probate timeline that you can download. Even if you're a trustee, the timeline's relatively the same, with the exception of the fact that you really don't have to have the probate court's permission to act. But the process of settling the estate is relatively the same. Download that and let me know if you need any additional resources, and I'll see you next time. Bye.